All right, and with that out of the way, I would like to introduce our keynote speaker for today, Professor Jack Beard, who will present on the limits of soft law regimes. Professor Beard is the co-director of the Space, Cyber, and Telecom Law Program at the University of Nebraska College of Law. He is also the editor-in-chief of the Woomera Manual on the International Law of Military Space Activities and Operations, and previously served as the Associate Deputy General Counsel for International Affairs at the Department of Defense, as well as serving as a judge advocate in the United States Army JAG Corps. Professor Beard, thank you so much for your time, and I turn it over to you.
Thank you. Thank you. I won't try to match Jeremy's jokes, but the federal government's just as funny. So I'm delighted to be here today and honored, and especially honored to see so many of my friends and former and some current students. There's nothing, or at least there's very little to compare in my life to how rewarding it is to see how my students have gone on and excelled, as I see so many of you here in this room. And it's a delight and an honor to be part of this military family and team, because we're all united here by one thing, and that's serving our country. And for us lawyers, that means giving accurate advice to our leaders, not fluff, okay? Not confused policy statements. The line between me and the flag officer or the ambassador or the assistant secretary is a clear line. I do the law. And beyond that, that's a policy question that I don't presume to say anything about unless I'm asked. This whole business of norms challenges that in a very difficult way. And so unlike previous remarks you heard, where you're tired of telling the general about the norms, my job as the lawyer is to continue to tell the general about it. It may be irritating at times. I'm not going to stand up in the middle of the room and say it, but ultimately my job is to keep the general or whatever the flag officer assistants are out of trouble. And so I'd like to walk you through soft law from a different perspective. I'm the dark side of the story here today on the second day. And so first off, let's talk about what this thing is. This area of non-binding things, technical and procedural guidelines, standards, best practices, principles, goals, codes of conduct, hopes, wishes, prayers, dreams, aspirations, and a long list of other things that used to come to my desk. There's something some foreign government wanted to sign. States do them, but they're especially generated by international and non-governmental organizations and interagency coordination and consultation groups. And academics love them. And they gather together in beautiful places in Geneva, and Zurich, and London, and they eat lobster bisque, and they sit around and develop all sorts of ideas about how states should behave, and they generate proposed codes. There's lots of them. I call the phenomenon soft law on soft law. So many different varieties of it that you have different groups suggesting different things about what different terms like due regard mean. We have a treaty, an outer space treaty. It's understudied, undervalued. It needs to be much more carefully looked at by our legal education teams in the military. And we can link up to this because all the states that are major spacefaring states are parties. Unlike cyber, this isn't the Wild West. We have an outer space treaty that we can hook up to and that we can try to develop. Anyway, these soft law standards that are out there, I'm not going to completely say they're useless because, as you heard yesterday, a bottom-up approach where the agencies, the space agencies of different states develop technical standards, as the Interagency Debris Mitigation Committee did, how a rocket is built so it generates less debris. States voluntarily create these standards. And then when it comes time to launch your rocket in the United States, you'll face a licensing requirement that borrows from these voluntary standards. And so even though it's not legally binding on the international level, all these countries, including China and Russia, try to adhere to these standards to generate less debris in launches. Didn't stop the Chinese from destructive anti-satellite weapons tests, but regular launches, it's a contribution. So I don't want to say that that's not of value. You also have non-binding voluntary groups like the Australian, where states set export controls to establish restrictions on the exportation of anything that can support the proliferation of biological, chemical, or nuclear weapons. That's good too. And states develop this and use it in their standards. But my friends, none of these involve limiting US military capabilities in space. And a consistent theme, as you go back to US military space policy, is we need to preserve our flexibility in space to do what we have to do if we have to win a war in, through, out of space, all the different adjectives and adverbs. We all rely on space. So we've got to do that. And that is a different animal that comes into play when we start talking about some of these codes. I'd also have to say UN General Assembly resolutions, which are not binding, they're recommendations, have in one bright shining moment generated the Declaration of Principles for Space in the early 1960s, when the world was scrambling to come up with rules for space. It later was essentially codified in the Outer Space Treaty. So in that one case, that General Assembly resolution rose to that. But these are rare examples. Everyone, though, that wants their soft law to become binding international law has one of two options. They either hope that lays the foundation for doing a real agreement in the future, or that through consistent state practice, out of a sense of legal obligation, it will become customary international law binding on all states. If you want it to be that way and you're pushing your rule, you love to call it a norm. You love to call it that because it conflates the big issue. Is this a legal requirement, or is this something that you're wishing, hoping, praying can become this? Well, I would distinguish these from a very worthy effort, however, that the Defense Department issued last year. It's a great memorandum. It's not soft law. It's a state's statement of how it's going to do business. It's an example for other states to follow. It represents good practice. It supports the mission. It's what we are and what we do. But the way it's written, my friends, it's a beautiful piece of legal workmanship for which I applaud my Office of General Counsel friends. What does it say? They could have said norms, right? They could have said norms, but why didn't they? Because they're good lawyers trying to protect their department. It's tenets. When was the last time you saw that word? When you were arguing with your landlord or something, right? Tenets, really? Really? Well, it's not an accident, it's there. They don't want to confuse you with norms, and they don't want this to then come around in the boomerang from states who love to use what the United States says against the United States and say, hey, you've been calling this a norm for a long time. It's a law, ha, ha, ha. No, it's a tenet. And also, notice also the beauty. You're not complying with or following the norm. You're acting in a manner consistent with this tenet. And by the way, you're going to do it until directed otherwise. This is the present intention of the Defense Department, okay? Until directed otherwise. I love this sentence, okay? This makes me happy. And you know, there have been a lot of really distinguished people stand here. I'm just in their shadow. I'm just the lawyer. That's all I am. And now the law professor, that's all I do. But it's a legal conference. And today, this speech is all about law, not the hopes, wishes, prayers, and touchy-feely things that some would like to have evolve into something better. But let's first talk about the soft law phenomenon. It's not law. I hate the word soft law. You like it if you're pushing it. It's soft law and you've got hard law, and you know they're kind of the same. This, again, if you have children, I have 4, saying something is a soft rule means get dad's car keys now, okay? Soft rule, it's like the comment in yesterday's panel, which I really enjoyed, you know, non-binding rules, what's that about, right? Well, it's not law. And in some cases, as I noted, it may have some limited value, but there's a darker side I want to talk about because it does present some risks, particularly when it touches at all on arms control. What's arms control? It's one of two things. It's limiting the conduct of military forces, what they can do, how they behave, or it's limiting the technology that they can use. Now, don't tell me about limiting technology in a outer space treaty, arms control treaty. As you've heard, anything that moves in space is capable of being a weapon. And the Russians certainly had the right to regard the space shuttle as a space maneuverable vehicle weapon. It could do things. If it moves, it's trouble. And then go down the next path. What's an offensive and defensive weapon? Please, in space. Presumably, if you have the right of self-defense, you have the right to weapons, but which ones are defensive or offensive in space? And of course, how can you tell what's up there because you're not inspecting sites in China and Russia when they launch? Anyway, that's technology side. Conduct, different story. You can, for instance, develop an international agreement to prohibit certain types of conduct that you can, in fact, monitor when you see the anti-satellite weapon blow up the satellite and generate all that debris. We'll talk about that a bit more in a moment. But I'd like to discuss then, for soft law, some misconceptions and some dangers. My students would recognize some of these things because they are a fundamental part of providing to your client the law and no more. Now, your client can ask you about what's happening, about recent developments, and you should be completely aware of them all and talk about the policy and so forth. But let's talk about the misconceptions. My first and favorite one is, it's so easy to do. You know, it's easy to put a note in a bottle and throw it in the ocean to communicate. Its success chances, not too good, okay? But this is so easy to do. Easy compared to what? Easy compared to sitting down with the Russians and Chinese and having that long root canal with them. True. Now, it's not on my resume, but I was a Russian major in college. I have a diploma from the 1970s from Leningrad State University as a Russian-speaking student there. I spent a large part of my adult life in the former Soviet Union. I've sat across the table from them for so long, and they are masters of the negotiation process. It's a game, it's a process, and I developed the character in dealing with them to be like them, and so we were just one big belligerent activity, the two sides. And friends accuse me of having adopted some of this in my life. I spent so long around. Well, don't play chess with them, and also evaluate when you're going to sit down. It is going to be a long process, but it's going to be worth it, because as we go through these different soft law things, fractional soft law, as I refer to it in my writing, is even worse than nothing in some ways, where a group of states purports to say they're going to stick with it. So you've got Fiji, Burkina Faso, and Bolivia on board, but you're ignoring the other major spacefaring states. That's of no value. So it's hard to do international agreements. It's also, though, easy, and this is the temptation for different actors in the Pentagon and elsewhere, as they call their lawyers in and say, we want to do something. And the lawyers explain how complicated it is. And so they discover, oh, but there's a soft law way to do it. It's so much easier. Why is it easier? Because you get to throw out all the requirements. You throw them all out. You know, you're the guardians as the lawyers here of your people, your resources in the department. You are responsible for them. Throw that all out. You don't have to worry about the things that go into an international agreement. Who's going to pay for this stuff? What are the obligations that might affect other departments? Is Congress going to hear about that? Stand by for that. You don't have to do any of that. You just go ahead and slap that baby down. It's a handshake, or in COVID times, the famous elbow, right? So throw out the CFR. That should be part 181. I had to quickly change. I revised this lecture based on yesterday's events to make it more topical, because you know you need your professors to be mobile, agile, but not hostile, right? Anyway, you've got part 181, which sets forth all these requirements about international agreements, and how you're supposed to be consulting with state, and how you're supposed to send it to the Congress and so on. Forget about that. This is just a piece of paper, and that is a dangerous place to begin something important, isn't it? But that's what I want to talk to you all about. I want to marshal three things here for you today. My own experience as a military and civilian lawyer in our government, my scholarship since then, and your common sense. Because deep down, something's bothering you, isn't it? Deep down, something's gnawing at you. Would you take your home or your car and do a transaction without it being legally binding? Would you? No, of course not. Why? The answer is easy. Well, that's important, right? Would you treat your country as anything less? This isn't the way to do business in a long-term operation in which you want to achieve progress, because you're immediately taking out actors that need to be involved in something interesting. And when the Obama administration tried to do this with the International Code of Conduct of Outer Space Activities proposed by the European Union, it was a disaster, and Congress is still watching, which I want to make very clear at the end here. Oh, by the way, you also throw out the DoD directive on international, which I used to manage. And I would note, though, there is a clause in there that says DoD decides whether or not it is an international agreement and they should be consulted. It doesn't happen all the time, but I tried to make sure that got put in some years when I was there. Throw that out. The rest of the department doesn't need to know about it. Nobody needs to know about it. You don't need to have it reviewed, even though, of course, the general counsel is the senior lawyer for the departments of the 6,000 military and civilian personnel appointed by the president. It's his job, her job. You don't have to worry about that either. You're able to just shake hands, sign the document, and go out. Oh, there's an example. Now, Mr. Rumsfeld, Secretary Rumsfeld, is signing it with the Norwegian Minister of Defense. I want you to know, Mr. Rumsfeld never smiled at me like that, okay? No, in fact, he wrote a book, Rumsfeld's Rules, and several of the rules noted how odious lawyers are, including one rule that said, keep it away from the lawyers. They're beavers who clog up the stream. Well, okay, so I'm a beaver, but I'm here still serving my country. I put a picture of a beaver on my desk too. I'm actually doing important things to help protect you, and I'll keep on doing it. But interestingly, in these sorts of signing ceremonies, we do the important ones, the international agreements, and then I have a slew of these other documents. We want to sign this tomorrow. You can't sign this tomorrow. We haven't gone through the procedures. Well, is there any way we can sign it? How can we justify this huge delegation from country X? Well, I can take it and turn it into something that's not an international agreement. Some of you have done this in the JAG offices you worked at. And so throw out parties, throw out agree, throw out done at. It's just a silly one-page document that says we met, we talked, we love each other, good things will happen, signed Bob and Volodya. That's it. But no one reads it. And the flags flutter and the cannons go off and each side declare, and I ask the press, do you want a copy? No, we don't need a copy. I tell my kids on TV, look, Dad's on TV today. Dad, you're just holding papers. I want to be a doctor. The tuition money's down the road for you, pal. Anyway, so it's really easy to do. It's also usually categorized as win, 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 win. And of course, that presumes that there are no downsides to this, and I think you're gathering that might not necessarily be the case. But two, I'd like to note here is, at the first, are we spending all our time on this stuff at the expense of the opportunity to work on legally binding agreements now? Are we? And are there some we could be doing? Is there some low-hanging fruit? Yesterday's panel talked about it, and my colleagues out there at the Secure World Foundation have been working on this. The idea that perhaps it is the time to sit down and develop an international agreement about banning anti-satellite weapons tests just to cause those destructive debris. Sit down with the Chinese and the Russians. They've done their tests. Sit down with the Indians. They've done it. They've got it. They already know they can do it. We can take care of satellites in other ways. Right now is the golden opportunity in arms control, which I also teach. It's the great chance where the big guys slam the little guys. The big guys have all tested their weapons. There's a long line of other countries that are thinking about anti-satellite weapons tests. Now's the time to do an agreement to restrict it, to do it. And while you're at it, you'd have the opportunity to say, by the way, we view this as a part of our implementation of the obligation not to cause harmful contamination of space or to show due regard or whatever. Link it up, make it state practice, implementing the Outer Space Treaty. The chance is there. The last time Congress asked in the article that I wrote, the senator asked, why aren't you working on this? To the Obama administration. I said, we can't have time for it. We're working on non-binding norms. That was the response. Okay, well, we have it sitting before us still today. And then the next question, again, as I ask, is this another soft law proposal? And who's going to be implementing all these different proposals? Are there different groups coming up with different definitions of due regard in theirs? Are they the same that we'd have for the Outer Space Treaty? It's just not win-win on a really fundamental level to be generating all these documents that don't have any legal standing and didn't go through anyone to get to the place where they are. Now, here's one of my favorites too. This is the new way forward, baby. Now. No. This is exactly the language in the Obama administration as they tried to do it. You need to look at two stories here. Cautionary Tales. I was great with Cautionary Tales with my clients. If I sat on the airplane for 8 hours flying wherever, I'd tell stories. You need to remember the cases and the other events in your life that matter and turn them into fables. Turn them into stories. Become a storyteller. Tell your clients in a way that doesn't offend or confuse or bother them funny stories about how people can screw up their lives in their country by making legal mistakes. I'm an expert, and it actually paid off in a big way for me as I explained on a long trip to Moscow to the ambassador a story about another ambassador whose carelessness resulted in the loss of 860,000 square miles of land in Greenland. It's a famous story of the Danish and the Norwegians and who owned Greenland. And I developed that with him, and he listened to it, and he enjoyed it, and there's a lot of laughs. When we were in Moscow, it was time for signing. The documents were passed out. Our translator had been retained outside the building. Why was that? They're passing around the texts, and I look at the Russian text. I said, this isn't the same text that we developed. It's different. And again, sad thing for the Russians, an American who speaks and reads their language. Oh, sorry. And so it wasn't the correct document, and the ambassador was preparing to sign it. And the moment was there, and the Russians were smiling. And I said, stop. And I looked at the ambassador, and I said, Greenland, baby, Greenland. It's Greenland. He said, okay, I want that back. And they pulled him back. Our translator got back in. And, in fairness to them, it could be that, the Justice Ministry wasn't involved and they changed it or whatever, but it was not the same document we'd agreed to sign. So develop those stories. And here's some stories for your illumination in this area. The first is Obama administration efforts. At the top of their list in 2011 is the promotion of norms of responsible behavior space when it comes to space strategy. And then the ill-fated, ill-advised, all of their adjectives and adverbs, proposed conduct for the outer space, the European International Code of Conduct for the outer space activities, proposed in 2008. And it's gone through many different editions and revisions, and is now, the latest is a 2014 edition, which is sitting dead on the floor at the United Nations for a lot of interesting reasons, which I'll discuss some here. And if you want to read others, you can read my article. But let's go back and look what the Obama administration said in 2011. At the very beginning of the space strategy, we will support efforts to promote norms of responsible behavior. And you go down, and near the end, it's, oh, and we'll retain the right to respond should deterrence fail and strengthen resilience. Okay, be sure and put that in. But the first effort's responsible behavior in space and norms to promote it. And then the Defense Department issues its strategy in line with this, and they're taking orders, and it says that not only are we going to do these things, but support the development of international norms of responsible behavior that, if broken, could indicate malicious or hostile intent, actually would be a deterrent. Really? Really? First off, do you break a norm? Yeah. But the idea that the Russians or Chinese would be deterred from attacking us because a few of us have developed these norms is a little hard. It's certainly not deterrence with deny benefits and impose costs. Maybe an assurance measure, but that's not a very good one. In any event, the Defense Department, though, threw in a great little proviso, which I've enjoyed, and that is, yeah, a broadly accepted set of international norms of responsible behavior will have positive effects on the safety, stability, sustainability. In other words, are the Chinese and Russians here, or is it a lot of other little countries that are interested but don't have major space operations going on? they've got to be involved. And if you can either deal with them directly, or you can try to pull them in through this soft law web. But even if you do eventually develop your soft law regime, they're going to have their own demands when they come in and want to negotiate with you, if they even want to participate. And the Russians rejected this because they have their own propaganda tool with their PPWT treaty that they're trying to push. That's been quite successful for them. They're not interested in this. They weren't anyway. But anyway, this is the story. So you can look this up and read it. It clearly applies to military activities as well as civilian. And there are provisions in it that aren't defined that limit what military forces can do. Most of them are things that if we defined it, we'd probably do something like that. Others are somewhat troublesome. And if you want to read a law review article, and that would make you 0.0001% of the American population, you can read my discussion of these issues in the aptly named piece, Soft Law's Failure on the Horizon, the International Code of Conduct for Outer Space Activities, written in 2017. And it was prescient at that time because it would go on to die at the United Nations. Anyway, if you'd like to read those things. Anyway, so this brings me now to talking some more about norms. This is a great writer. I like him. He's very thoughtful. He's really a good international relations guy. Michael Crepin, writing Weapons in the Heavens, a radical and reckless option. Lots of good content. But when he strays into norms, this is what I think is a typical thing. Laymen and policy people use norms however they want. Just like in cyber, when Uncle Leo sends you an email you don't like, you're the victim of a cyber attack, right? You know, spam from this company. Cyber, everything is a cyber attack. It's been pulled back, but the vernacular is still out there. These legal terms, you have to accept they're going to keep getting used incorrectly. But if you're a lawyer and you're writing, you have to avoid things like this. He starts out saying, an essential element of space assurance is the strengthening of existing norms against the flight testing and deployment of space weapons. There's no such law. And as said yesterday in the panel, if there's a norm with respect to anti-satellite weapons testing, it's probably that, hey, we get to do anti-satellite weapons testing. You know, that's something that we'd like to have. But then in the next sentence, it's many norms exist for spacefaring nations. And it proceeds to talk about weapons of mass destruction, helping astronauts in distress, registering space objects. Those are all laws. Those are all part of the Outer Space Treaty. They're binding treaties in the United States of America, obligations. And this confusion is, you can accept that it's there and consider it to be harmless until you look at what happened to the Obama administration. If you push and push and push something, say, we really want you to do this. This is a norm. If you're a good person, if you're a good country, if you want to be responsible, you should do this. Never mind, we haven't made it important enough to put an international agreement, but it's still really important. You've got to do this. Why do we have to do it? Well, it's a norm. It's what responsible states do. You come very close at some point to saying, well, you kind of are obligated to do it. You should do it. At what point do other states reasonably say, hey, the United States is suggesting that this is a kind of a legal obligation? And it'll be brought, it's always true that international law is used. It's our sword and shield, but we fall on it inadvertently and accidentally many times, and states would come back to us and say, wow, you said this. It sure sounded like you meant a legal obligation. Well, when Obama administration officials went out promoting the code and similar soft law things, they really pushed that these are norms we need to follow. And Congress listened to this. And given that it affected military activities, Congress started getting really concerned that there's a document that they've never seen, that never went through any procedures, that's being pushed by the administration as something that should be respected. And the people pushing it are also hoping maybe someday it'll be customary international law. Maybe someday it'll be the basis of international agreement. Let's push, push, push. Well, Congress wasn't convinced that these arrangements, non-binding or not, the way they were being described, would not adversely affect US military capabilities. Just like you have to talk to the Chinese and Russians about something, you've got to talk to Congress. Not that they're the same thing, but they're a problem, right? Okay, so the criticism of this approach at the time and by various authors is that it represents a sort of backdoor arms control. You don't go through Congress. You don't really elaborate on what and how you're being restricted. You push these norms of international cooperation, and then one day the United States is unable to do something it wants to do in space because we've signed up to this thing. So the congressmen start writing. That's what they did. 37 write to Congress in 2011 saying, we are deeply concerned that the administration may sign the United States onto a multilateral commitment. I like that too. Not even saying it's an agreement, but it sure looks like a commitment. And we're Congress, and we are really interested in commitments that affect the United States military and capabilities. And of course, as any of our leaders here know, there's a whole lot of different committees in Congress interested in how DoD does its work. Even they're concerned that a multilateral commitment like this, with a multitude of potentially highly damaging implications for sensitive military intelligence operations, we're concerned, and there's a tremendous amount of commercial activity involved as well. Oh no, well, what happens? On a breakfast luncheon, the State Department, Secretary Clinton tells the delegates, the people assembled there, by the way, we're not doing that outer space, that code of conduct. What? No, we're not going to do that. We'll develop something else. Well, they were angry because they'd worked with the United States up to this point, but the Clinton administration, the Obama administration didn't want to go any further on this. Fine, it's their privilege. Congress didn't give up. They kept on writing saying, we're glad that you didn't do that, but we're still concerned that this process here could establish the foundation for a future arms control regime that binds the United States without the approval of Congress, which would bypass the established constitutional processes by which the United States becomes bound by international law. It's never been resolved conclusively under our Constitution what has to be a treaty and what doesn't. That's left for the politics of the Senate, essentially, to decide. But you should know this interesting piece of law. You probably have never seen it before, but it's one that, as a lawyer, I like to bring to the table because that's what I do. 22 United States Code, section 2573, no action shall be taken pursuant to this chapter in foreign affairs or any other act. That's a great word for the lawyers too, right? Don't tell me it's just DoD money. Don't tell me it's just State Department money. Don't tell me it's just authorization or an appropriations bill for 1993 funds. Don't tell me that. This or any other act, you can't do this. Don't do anything that would obligate the United States to reduce or limit the armed forces or armaments of the United States in a militarily significant manner, except pursuant to the treaty-making power or authorization from Congress. And that's what the congressmen began citing here when they remind the administration, skip too far ahead, when they remind the administration about established constitutional processes. They're talking about this. They want it to be an agreement, and they want to have their vote on it. And you can understand why they'd say that. And suddenly this whole thing becomes a bigger and bigger controversy. And in 2013, in the National Defense Authorization Act, Congress steps forward and says, and remember, this isn't just for 2013, it's an authorization bill. It says, if the United States becomes a signatory to a non-legally binding international agreement, lawyers, when you mean it to be an agreement, call it an agreement. Otherwise, it's a document, it's an instrument, it's the documents, international documents, the better word. If it's going to be legally binding, call it the agreement. Anyway, they use it broadly here, and they say anything concerning an international code of conduct for outer space activities or any similar agreement, document. At such time as the United States become a signatory, we want the president to submit to Congress a certification that this document, this agreement, has no legally binding effect or basis for limiting the activities of the United States in outer space, or basis. Think about what that means. So it can't be used to form customary international law. It can't be used as a basis for international agreement. And then you get a really interesting question, which the academics now are the only ones that really enjoyed writing about, is who decides what customary international law is for the United States? Is it the executive branch by itself? Or is Congress able to get involved in this as well? Legally binding obligations that affect US military forces, you think they probably want to be involved. And it goes on to remind the folks in the Pentagon that, we are citing this law, that no action will be taken that limit our armaments or capabilities. Don't do it without doing it through this process. Anyway, it died, it's gone. That era is over. And yet it is a cautionary tale about going down this road very far and not dealing with Congress and not spending time making it into an international agreement and dealing it with the actors you want to get to, no matter how unpleasant they are. Someone mentioned yesterday, during very unpleasant times with the Soviet Union in 1972, there'd been enough near misses or near hits, actually. It is a miss, as George Carlin would say. That would be a near hit of ships, and so we're out in the Black Sea. That an agreement on maritime incidents was developed, which had a long list of things that the two sides were potentially going to be getting in a conflict over, about the way their ships maneuvered and the way they did their exercises and so forth. Those were not good times in 1972. And true, as another panelist said, space objects aren't these gray steel things floating around, but there's much to be said about the sort of due regard elements of that document and tension and stress at the time that would suggest that it'd be possible to nonetheless table something with them. Maybe not at this very instant, as photographic imagery confirms all sorts of awful things in Ukraine, bringing up also the fascinating subject of these satellites that are doing all this, taking militarily useful pictures, Starlink with the internet that the Ukrainians say they use with their drones. What's the status of those satellites? Smiling at Brian Whedon, we were interviewed by the Washington Post, and he said things that were aggressive in this regard. Where are we with these satellites? And if they're hit, is that the United States being pulled into the war? Are they military objectives? These are all questions that relate to how well military lawyers understand the Outer Space Treaty and the different connections to space objects that exist, as opposed to ships and planes with nationality. But I digress. I want to wrap up on the world of space, of soft law problems, with another thing I like to refer to. I'm not the first to say this. I'm the first to call it this, but various writers have opined on this, that soft law instruments, by definition, they can't even define what cheating is, because they don't have definitions. They're not legally binding. They have no enforcement mechanisms, no legally binding dispute resolution. And they also don't have the benefit of the Vienna Convention and law of treaties telling you how you interpret international agreements. That's all gone when it's just soft and non-binding. So the only verification that the other side is doing anything remotely consistent with this new proposed soft law is their own societal verification process, which, in America means, holy cow, all these NGOs running around, all of these congressional committees, all of the free journalists that aren't shot when they publish something the president doesn't like. That's what America has. And as leaders here have noted, we're giving away so much information other countries don't. It is disconcerting, it is unsettling. And when a sensitive satellite doesn't take off from America, there's an immediate inquiry by the NGOs and journalists. Hey, isn't this an early warning satellite? Why is it not taking off? What's the problem? What's going on here? Forget that with China and Russia. You can't get near their facilities when they launch these things unless they want you to. We have our own self-verification stuff going on. There will be people who rightfully say, hey, haven't you pushed this as some norm and you're building this or you're doing that? Authoritarian leaders don't have to worry about that. There's no societal verification going on. That's all you've got with these soft law things. So there's a chance that the United States ends up being on the wrong side of things that restrict us, but have no effect on the others, even under a soft law arrangement. Arrangement is a nice word as well. Back to the legal framework as I conclude. How do we do what we all would like to do by moving forward to reduce the possibility of mistakes, miscalculations, and unnecessary conflict in space? How do we do that? We in this room all want that. Others define responsible conduct quite differently than we do and are willing to take chances with people's lives and resources that we don't want to take. Americans have a tendency to refer to these actors as crazy. They're irrational. They're not irrational. They just have different sets of priorities and values and are willing to take bigger risks. And we are left hoping that perhaps they would have some similar interests in avoiding an unnecessary conflict. I think we've heard a litany of things here at this podium. General Dickinson explained things that are very disturbing going on. How do you possibly get at dealing with all of these things? Well, in addition to pursuing whatever agreements you might with them about these activities, it's really, really time for the United States military in particular to embrace an intensive study of the Outer Space Treaty. There's a lot going on here that hasn't been studied. I spoke at the Army JAG Corps headquarters on this. I spoke at the Air University. I'm off to the Naval War College. The battle is right here at this academy with the front line being Colonel Vienna and Tim Goins out there and other professors here teaching the Outer Space Treaty and understanding how it applies so that hopefully, you know, if you do this, there is a critical need for a reviewed focus on and study of the international legal framework provided by the Outer Space Treaty, because there are some answers there and there are some definite areas where it's not answered. But ambiguous terms aren't as ambiguous as some like to portray them if you go back and read the preparatory work and the negotiations of these terms, which for some reason has not been of interest to many of the European authors. And yet you can go back and look at the debates over some of these words. Some of the words, sorry, there's not much there. Others, though, many enlightening things. And so remarkably, to date, there's no extensive examination of military space activities and operations in space. It's never been done, which is remarkable, but it's an old treaty that was written rules for the future, and we didn't have the contested, space situation we have now, and we certainly didn't have private businessmen launching up tens of thousands of satellites, which the Chinese feel threatened by as it passes near their space station. It's a different world, but the legal connections with these satellites, I find, are completely not understood by a number of different commands that I work with, because they've never really had to be forced to study the Outer Space Treaty in depth. And after all, it is a treaty. It's worth your time. And so it's in that light that I became involved some years ago with a project that is just a project of several universities gathering together practitioners and some government people acting in their private capacities in an effort not to spell out how the world should behave, but rather to try to give a clear possible restatement of sorts on what the law is. Not what it should be, not what it could be, but what the law is. This is the Woomer Manual, forthcoming, hopefully by the end of this year, from Oxford University Publishing. The Dutch government has been so kind as to allow us to use their diplomatic network. They've distributed this manuscript to interested countries all around the world. The first country that said they wanted to come was Malaysia. They have a special place in my heart. So anyway, they're all coming in. That document's making its way around. And the beauty of it is we will have some state commentary on things that have never been discussed before, in part because talking about the law of armed conflict in space has been a taboo at the United Nations. States have resisted talking about it because they say it legitimizes armed conflict in space. This is one of the few ways I see of states having the opportunity to say something about some of these things, because fortunately we've never had an armed conflict in space, but the armed conflict rules, some of them don't fit very well in space. Others have some very interesting possible applications. The Woomer Manual tries to outline those and discuss them, but it's not going into futuristic speculative stuff. So it's divided into the rules during peacetime, the rules during times of tension and crisis. That's particularly UN Charter stuff. And then in the unfortunate incident of an armed conflict, how the law of armed conflict applies in space. And that means you have to go through each provision in the Outer Space Treaty and ask yourself, if there is an armed conflict, which parts of it apply and how do they apply? Which parts apply between the belligerents, and how do you treat all the other countries that don't want to be involved in the conflict but still want to retain their rights under the Outer Space Treaty? It's an article by article attempt, because you're supposed to reconcile to the maximum extent possible the rights and obligations states have under existing law, and only suspend them when the law of armed conflict demands it. Anyway, that's the idea. But quite apart from that document is the larger issue about it's time for us to be able to articulate as best we can and articulate as best as we can the rules that we have, and perhaps through that provide a bit more predictability, a bit more possibility of avoiding miscalculation. It's worthwhile. It's what lawyers do. And for you, my fellow JAG and civilian lawyers, it is our law and worth your time. And so I'm an advocate of that, and I'm not dismissing some of the soft law approaches you've heard about, but I guess at the bottom line is you shouldn't rely on it too much or push it too hard. And you might want to reconsider whether or not it would be better to be doing these things as an international agreement, as some of the panelists yesterday suggested with respect to mitigating debris. Well, that is a wrap up. It's time for some sort of thoughtful slide for questions. There we go. It's over now. You've endured that root canal. The lawyer's done. Now I just ask questions. Oh no, I see a smiling face back there. Go with Mr. Whedon.
So Brian Whedon, Secure Foundation. Thank you for that eloquent dismissal of my life's work and professional career. I know better than to ask you a legal question, so I'm gonna ask you a political question. I very much agree with your assessment of the shortcomings of soft law and the need to reinforce the existing hard law and think about new hard law. But the whole reason the Europeans proposed code of conduct was the United States was openly hostile to discussing any hard law agreements. And we have been that way politically for a few decades now.
Yes.
So that is the real crux of the question I'm sort of going to push back to you is, how do the lawyers help convince the politicals in the United States that hard law can be useful, both in terms of saying the things we've already agreed to in the Space Treaty are worth actually upholding and solidifying, and perhaps some new hard law?
This is a really good point. And I don't want to dismiss any of your work. Brian Whedon is one of the most, he is my living encyclopedia of space issues, technology, weapons, and trivia, and a valued technical consultant for the Wormer Manual. What I'd want to say is, first off, when was the last time the United States did a treaty at all, right? Now, it doesn't have to be a treaty. There's other internationally legally binding options, but each administration comes in with a political stigma, whichever political party. One political party comes in and isn't trusted, like, don't mess with the military, we don't trust you at all. The other political party comes in, depending on their attitude, it's like international law is for losers and communists, we're not going to do it. So you have these two extremes. We want everything to be there and no one trusts us. We don't like international law, we're not going to be introducing any of these things. And those political fortunes have dictated the failure. It has to come down, though, to establishing some sort of trust with Congress, to come to them and say, we have a very limited proposal here, and it's good for US national security. We've got no reason left to be doing destructive anti-satellite weapons tests. These countries are also probably not eager to do it more. We could make a significant contribution to reducing space debris. This is good for the United States military and US national security. Oh, Senator, please listen to us, right? It begins with the penance, right? And the walking on the crushed glass down the hallway on your bare feet to ask them, can we please talk about this? But you bring up a good point that there hasn't been an international agreement for space since 1979, the ill-fated Moon Treaty, which I need to remind you, the lawyers in the room, don't you ever get stuck confusing that treaty and its obligations with the things in the Moon and the Outer Space Treaty, okay? If I leave you just with one thing, don't let people slip Moon Treaty stuff in, because the Moon Treaty has a clause in it that says that prohibits any hostile action, or get this, any threat of hostile action on the Moon, which isn't defined, but I would think a weapon might fit in that category. Anyway, only 18 countries have signed the Moon Treaty. Worry about it if you're in Mexico or the Philippines, but don't worry about it here, and make sure you don't mix up the Moon Treaty, the last agreement that was done in 1979. So no agreement since then. And a lot of it comes down to a lot of distrust between Congress and which administration is in power and what the administration wants to do. The option, though, of just pursuing soft law isn't, as I said, it's certainly not a guaranteed solution. You might look at this and say, well, this is all we can do, so this is what we're going to do. And the think tanks and academic groups that generate proposals and so forth, if they could be working, as I know Secure World Foundation does, with Congress to say, hey, you know, we should consider doing this as something really significant and serious as an international agreement, depends on, of course, our politics and our politicians and our leaders. We're left with rising threats and tensions, a desire to avoid miscalculations and mistakes, and for the lawyers, an attempt to provide whatever clear guidance we can in the face of all of this. It would be wonderful if we could put more bipartisan effort into having an international agreement effort, or even to sit down with the Russians and Chinese and begin not with their proposal. Never start with the Russian proposal. Never, never, ever, ever. You know, it will only, by the time it's over, you'll be agreeing the sun rises in the west because that was in part 4 or whatever. Don't do that. Start at the beginning with them about what we could agree on. Hard work, unpleasant work, and people will be suspicious of whether or not this is at a time of crisis, especially right now, yielding to authoritarian governments and what they're doing. But we're talking, though, about rules that have been around for a long time, but now really are coming into focus as we face this ever increasing number of threatening actions, which unfortunately don't violate provisions of the Outer Space Treaty. After India's test, they had blasted China for their anti-satellite test. India said, hey, you know, there's no weapons prohibited in space except weapons of mass destruction, which is not what India had said before. And that launching these anti-satellite missiles into space, that's not a weapon. And India opposes the weaponization of space. Okay. So there's more and more military activity and more threatening stuff. And we're here talking about how to deal with it. And if you do soft law approaches, you've got to be thinking about the disadvantages as well. That's too long a response, so I have to be quicker on this. Who's next? But Brian was worth it there.
Sir, we have a couple questions and comments that have come in from online.
I'll bet.
Mr. Michael Listener had a question near the beginning of your presentation, which I believe that you largely answered, about the wisdom of using the word norm versus, for instance, tenet. But he did want to add, on a side note, those of us on the dark side have more fun. I'm going to try for a double header question, both of which involve kind of binding treaties. Mr. Harvey Rishikoff asks, how does 22 USC section 2573B, right, the binding limits on US military capabilities in space, how does that affect status of forces agreements? And then Mr. Trevor Hinn asks, could you please expand on some of the topics that you hinted were low-hanging fruit in terms of kind of binding international legal agreements? What do you see as the greatest barrier to pursuing more legally binding agreements?
Let's see. Well, with respect to the last one, my first low-hanging fruit one is an area where there would be an incentive for the states involved, the major space players, to agree on stopping destructive anti-satellite weapons tests. It wouldn't prohibit their use during armed conflict. It would just be about testing, the same way the Partial Test Ban Treaty also bans nuclear weapons tests. That would be my lowest hanging fruit. Of course, it's a very high tree, I suppose, to do any international agreement in this area. Back to the first question, I just say I should give a shout out to Mr. Listener because he was one of the first people to write anything about the imminent troubles of the International Code of Conduct and what it was, how difficult it was going to be to get done. So I should recognize that from another author out there. And on the second one about our status of forces agreements, I've negotiated so many in my life with so many in the Middle East or Near East, South Asia in our world. And also when we were demilitarizing things in former Soviet republics with the status. With respect to most of our status of forces agreements, they are treaties. And so Congress has their shot at it. And the Supreme Court has ruled famously in situations where we have turned US military personnel over to foreign judicial systems where they are not treated the same as they are in our system, that despite that difference in the administration of justice, those treaties were still acceptable and binding and so on. So there's a large hunk of study on this in this area if you want. Plus these SOFA agreements really are shared jurisdictional arrangements where we give some and take some, they give some and take some, and it's the price of operating in these different countries. And so that's never been invoked in opposition to it, but that's also in part because Congress has had more of a chance to oversee these basing agreements. Not all, some of our most important ones in the Middle East are classified. Congress has seen them, but there's been no objection raised. So I guess that would be my answer on those three. The deafening silence that my students so fear as I await their answer to my questions.
Thank you, Dr. Beard, for this excellent presentation. Really
Thank you for
appreciate it.
yours yesterday. Yeah, it was good.
Kudos. I'm curious what you think if there are existing models that could be used or adapted to maybe at least bring parties to the table. I'm thinking the intergovernmental agreement for ISS, you know, a success. Intelsat helped build the satellite communications industry in a lot of ways. Maybe other domains, the maritime domain, the airspace domain, other models, are there things we've done in the past that have been successful that could be adapted?
Well, you bring up a really great one there with the ISS. That would be an internationally legally binding agreement that's occurred since 1979. Not on the same scale as those agreements, but that's a fabulous SOFA agreement, to the ultimate SOFA agreement about jurisdiction over each component of the space station and who owns the intellectual property rights when you develop it, and this one, an amazing document and a spirit of cooperation before the Russian Roscosmos director threatens to dump the satellite, dump the ISS on the United States. At the time, it represented quite an important development in international cooperation in space. And the Russians have said they're done with it. US law prohibits us from working with the Chinese, so the Chinese aren't involved in it. And I think the era of international space stations like that may be over, at least the way it was originally designed. So sadly, that represents an issue that isn't probably going to be repeated. Let's talk. Your question brings me to a project of that I was discussed yesterday. Maybe this is the right time to talk about it. The Artemis Project. What is that? Well, it's non-binding, says NASA. Non-binding. It's described as this joint. It's not called an agreement. It's posited as the way these states envision going. The states are signatories, not parties. All that. And they're going to go there and they're going to do things on the moon that they say are consistent with international law. And yet there's issues of resource extraction going on to power the facilities. And a lot of money is being poured into Artemis. And it's all founded on a collaborative enterprise with these 13 states now that have decided to do it. The Russians are outraged. Who gives you the right, they say, to be deciding how the moon is going to be settled by people and resources exploited? And they have a point in the sense that the Outer Space Treaty only goes so far. And more people suggest that if you're going to have exploration of the moon, extraction of space resources, all these companies and countries involved, it would be a good idea to start developing some sort of legally binding agreement about how things are going to work. That hasn't happened, but two different outgoing generals that I talked to both said to me, not officially, both said to me one of their greatest worries for the future was that the United States military would be dragged into conflicts in space as for companies. For company A dealing with Chinese company B. And of course, everywhere humans have gone, where there are scarce resources, they fight over them. And the moon has this magnificent piece of real estate on the South Pole. The Shackleton crater has deep in it a lot of ice from comets deposited. Water is there. Light never touches it. It's extremely cold. It's a great place to go to find water to power things. And it's situated right next to the eternal peaks of light, which, because of the way the moon is tilted, is always illuminated. Great for solar panels, great for equipment so it doesn't freeze up. That's a prime piece of real estate that's the focus of some of these discussions. Isn't that going to be contested? In what world would we, in what universe would we consider that to not be potentially problematic? So, you know, you have a fair number of incentives to perhaps work. The Europeans are especially adamant about this, that we need to have something governing space resource extraction and so forth. The United States Congress has stepped in and said, hey, we go there, we mine, you're a US national, you can own it, you can transport, you can sell it, you're good. You go get it, is what the US Congress says. But that statute is only applicable to US nationals. So the Russian doesn't have to worry about that on the moon. We have some, not in the too distant future, pressing needs for working out some of those things. But right now, everything, if you're trying to deal with European ministries right now about anything, they're consumed quite appropriately by the crisis we find ourselves in on their eastern border. So it's kind of hard to talk about what we're going to do in the moon today with what's happening in Ukraine. But there are places where you could make a strong argument it would be in our interest to develop some sort of rules of the road for some of the space exploration, resource extraction. And of course, the temptation would be to do the Artemis approach and just keep on doing it on the side. The Artemis Accord is fully publicized. It's not hidden from anyone. It tries to be pretty basic and generic, and it tries really hard not to be threatening, but it is regarded as a problem by the states that are not looking at doing the moon that way. So that's a potential area for conflict that we might be well served to worry about a bit more when the time is right. But questions of any other sort, online or here? Excellent, in the back.
Yeah, thank you very much for the remarks and this question that we find ourselves working through. And you've been kind enough to give us a little bit of your time, at least with some of my colleagues in the UK and in the Ministry of Defence and in the Foreign Office.
You guys were great. Thank you.
I suppose I'm going to agree with you and disagree with you, because you know the policy position that we have about how responsible space behaviours is a shaping approach that we want to use to actually impact now on the activities that we see. I'm going to sound a little bit boring, but I'm going to take us back to this. If we don't focus this idea of hard law on physical actions in space, the stuff that's remaining is on Earth, whether it's missiles on Earth or lasers, whatever it is. How do you think it's possible, because my colleagues tell me it is possible, to write that into an international treaty on this sort of idea of the whole of the threats against a space system? Or do you think we're barking up the wrong tree in terms of low-hanging fruit? In terms of lasers and weapons on Earth, should we be doing that as part of a space treaty, or should we be doing that as part of something else?
And when you talk about this area that you're focusing on, you're talking about better defining the threat, assessing, describe how your approach would be about the threat.
So imagine we are talking about a few months before an expected conflict, and a nation starts lasing our satellites so we can no longer image their ballistic missile silos.
Okay, well, so this is wonderful. Where to begin? The shaping approach is not irrelevant. I mean, the United States statement of how we're going to behave and other countries that we're working with, trying to set responsible behavior, if it's done properly, if it's not over exaggerated, if it's not made as something that can come back and bite us, there's possibilities for that. I'd trust the United Kingdom more on that than just about anyone, because I would share with you all, there's practically no law of war manual as complete and as thoughtful as your law of war manual that the United Kingdom developed. It has been a great joy in my life to have it to turn to, because people in the United Kingdom have obviously thought about a lot of problems and put them into categories that I find very helpful as a lawyer. So the mechanism whereby you would describe this conduct is one thing, and how you would reach some sort of understanding with others about it. But the larger question is, let's just take the lasing of the satellite. How much time do I have? Let's just take the lasing of the satellite. Now, we already know from what you heard previously that just about everything is jammed now. Jamming is happening all the time. I cannot call it a use of force. I can't even call it a violation of international law other than it violating the ITU to the extent it does. And that's because everybody's doing it and nobody's complaining about it. And every US military exercise begins with, hey, everything is jammed. What do we do? What do you lawyers say? Oh, we don't know what it is. No, it's happening all the time. So is spoofing, which is more of a cyber activity. But the use of the electromagnetic spectrum to cause this temporary disruption with radio waves that overwhelm is not unlike a flashlight shining in a lens that temporarily blinds those sensors. You can go along the electromagnetic spectrum and see the microwaves doing the same temporary disruption and so on. And you have to ask yourself, what are these temporary reversible effects? The standard can't be, we're going to measure everything in terms of bad effects. The missile that flies by you didn't hit, but that doesn't matter. It could be an attack, or it could be an imminent attack. It could be a number of different things, that missile that flies by you. Something that temporarily blinds you is, as I think some of the peer review comments I got back on WUMRA from military people were saying, we're looking at a holistic experience here. In a time of tension and crisis, like you described, the temporary reversible effect may be the first wave of an imminent attack, or not forget about time of temporary crisis. What about early warning systems? Any interference with them at all, no matter how marginal, is going to be treated very seriously by both us and the Russians. And so it's hard to come up with some standard that says, when there's this much damage, baby, that's a problem. That's not useful in space. That may work for some in cyber, but that doesn't work in space. So, it's hard to write that into some sort of legal document, but it certainly has to be in your policy, your internal policy understandings. It's much like rules of engagement that are classified that you've really worked out that you're not sharing with the rest of the world because you don't want to know how close is, right? I always admired the unclassified and classified part of rules of engagement, because it was always interesting to me why the classified part was classified. Well, there were good reasons looking at the classified why you'd not want the other side to know, only 1,500 meters or whatever. You don't want them to know that. So that kind of makes an international agreement that spells any of that stuff out somewhat difficult. What would be useful, though, is for there to be a better understanding amongst the countries about how they're going to categorize the uses of force. And in outer space with all the, of course, you've got all the great kinetic kill vehicles and all those wonderful things that's very similar to what happened on Earth when the UN Charter was developed. The electromagnetic spectrum, though, was around during World War II as well, and the UN Charter explicitly talks about how disrupting communications isn't a use of force. I think you have a threshold that you can generally say isn't rising to the level of a use of force, but there are going to have to be big exceptions for that given on the circumstances, which is why it's kind of good to put a separate set of analysis on times of tension and crisis, because things are going to be different. And so is harmful interference and due regard in those periods too. And of course, during an armed conflict, those are gone. Due regard's not something you're doing with the belligerent on the other side. But I understand the desire to shape, but I'd continue to offer the cautionary tale, which you all seem to do very well, and that is to not use words in a way that comes back to bite you and put too much emphasis on the wrong words, and you're careful in that. You've done work on the word sovereignty that I appreciate as well. An overextension of that term means every single thing we do is illegal in another country, which drives me crazy because that's not what I want to tell my commander. Oh, it's all illegal. I don't know. It's just a terrible world. We should just give up now. You know, that's not it. So thank you, United Kingdom, for your stand on that. But anyway, I'd be hard pressed to make it into some sort of international document right now. But you're on all the right tracks and worrying about the degrees and the rules of engagement that you're going to have in this situation in space.
That was a very enlightening and entertaining presentation, so we very much appreciate it. And thank you also for your years of service to our nation and for taking the time out for us today. Thank you very much.